How much does reputation matter? When it comes to choosing an attorney, it matters a lot. That's why folks across Wisconsin have trusted the attorneys at Habush, Habush & Rodier for nearly 100 years. While they've built a national and statewide reputation for winning cases, here in Madison, they're your neighbors. Deeply rooted in the community, their attorneys are personally committed to helping clients recover with the kind of hometown service Madison knows and loves. For all types of personal injury cases, Habush is the name locals trust. Habush, Habush & Rodier, national reputation, hometown service. Visit Habush.com or call 1-800-2-HABUSH. Want some summer fun for a good cause? Loop the Lake is coming up Saturday, June 14th. It's a go-at-your-own-pace bike ride benefit for Clean Lakes Alliance, presented by Lake Ridge Bank. Riders start and end at Olbert Park and travel 13 miles clockwise around Lake Winona. And perk? Kids 10 and under ride free with a paid adult. You in? Sign up for Loop the Lake today. Go to cleanlakesalliance.org/loop-the-lake and use code BIKE10 to save 10%. Today on CityCast Madison. The Wisconsin Supreme Court's current term closes at the end of June, which means it's decision time. The state's highest court has a load of outstanding cases to rule on, including major ones like the 1849 abortion ban. Ahead of this consequential session's end, we sat down with Cap Time state government and disinformation reporter Erin McRory, who's been covering the court. It's Wednesday, June 4th. I'm Bianca Martin, and here's what Madison's talking about. Erin, welcome back to CityCast Madison.
Thanks for having me.
Yeah. So the Wisconsin Supreme Court is in its final month of this session, and there are a ton of outstanding cases. And some of those are major cases. We're talking abortion access, partial veto power, and autonomy for state agencies. So it seems like the clock is ticking. Is it crunch time?
It is, or it should be, at least. We're all kind of waiting with bated breath on our ends to see how often they drop opinions, which opinions they're dropping first. Obviously, like you mentioned, there's a few key cases that people are really waiting for that will, of course, decide what other cases come down the pike. So you mentioned abortion, for example. If the Supreme Court rules that the 1849 law stands, then the lawsuit that Planned Parenthood filed that the Supreme Court has said it will take up but hasn't actually scheduled arguments for yet and probably won't until next session, Planned Parenthood is arguing in that case that there is a constitutional protection. And that lawsuit will only really be relevant if the Supreme Court rules in its case that we're waiting for the opinion on that the 1849 law stands. If they rule that the 1849 law is not applicable, then that lawsuit about constitutional protections isn't super relevant. So there's a lot riding on these decisions, obviously the immediacy, right, of what laws are standing law and what, for example, state agencies can do, but it will also play a role in what lawsuits come down the pike next session.
Right. And it's almost like teachers, they go off for summer break and then they're back in the fall. I want to talk about the caseload. So if the Supreme Court decides on all the outstanding cases, they will have ruled on 23 cases in total, I understand, this session, which apparently is a historically low number. What's going on there? Why is it so low?
Yeah, it is. This court is the slowest in recent history. And I spoke with former Justice Janine Gesk, and she was talking about, she served on the court from 1993 to 1998, and she was sort of reflecting and was like, oh yeah, we ruled on 70 plus cases in one session. And it's hard to say for certain why there are so few decisions from this court. Some folks say it's because of the sort of intensity of the ruling. So obviously we saw legislative district maps. That was a really, really big decision. and affected, obviously, the, election coming up and how the legislature, was balanced among Democrats and Republicans. So some legal scholars will say that it's not necessarily the number of cases, but the types of cases, and that maybe this court is taking fewer cases because they are taking up issues like legislative maps or like abortion access. But it is really hard to say. Like, there's no hard and fast way of saying this is exactly the reason why they are issuing 23 decisions as opposed to 75. But it is notably slow. And the fact that they are waiting until so late in the session is also interesting, especially this year, because come the end of the month, now Chief Justice Ann Walsh Bradley is retiring. And so the members of the bench are going to be different in the fall when the session starts again. And so they are really under the gun to issue all of the decisions that they have heard arguments on, because they can't issue decisions that one bench has heard arguments on and then have a different bench issue those decisions.
Really? So, like, if the decision isn't made now, it's like, I mean, they'll have a different lineup and, someone will not have heard the arguments, basically. The new justice. I mean,
that's exactly it, is, Justice-elect Susan Crawford will be on the bench starting in the fall, but wasn't a member of the court to hear the arguments in, say, the abortion case or, some of these separation of powers cases or state agency authority cases. And so without hearing the arguments and looking through all of the evidence, she wouldn't be able to, participate in a decision making.
So she'd just sit it out. They're not going to have a new hearing.
No, they wouldn't have a new hearing. She would just recuse herself, but it would be messy. So the goal is for them to issue the decisions on all of these, impending cases that they've already heard arguments on. And it's been a minute. For example, it's been months since they heard oral arguments in the abortion case. That was in November. And so the fact that they're still deliberating, they haven't issued a decision on that one, is notable.
Yeah. Well, I mean, as you just laid out, if Crawford were to sit out, wouldn't the ideological balance of the court be 3-3? Mm-hmm. So there'd be 3 conservatives leading justices and then 3 liberal leading justices. I wonder what's happening in the background and why everything's a little delayed.
I always wonder what's happening in the background. I would love to be a fly on the wall, but I'm not. So I have to wait, just like everybody else, to see what happens.
Right. We know what we know. I should share a brief word on the balance of the court and its composition. So a little background. The court currently has a liberal majority, right? So that was first secured back in 2023 with the election of Judge Janet Protasiewicz. So there is a 4-3 liberal to conservative ratio. And that, quote, liberal majority was maintained with the recent election of Judge Susan Crawford. And by the way, having a liberal majority is fairly new, and a continued one is like a big switch up, considering there had been a conservative majority on the court until Janet Protasiewicz was elected, going back to 2008. So these are kind of new waters.
And since then, of course, as we've seen, these campaigns for Supreme Court have become very intense. I mean, they are technically nonpartisan seats, but we've seen the state parties get very involved in campaigning. There have been, super heated campaigns, massive spending. It's interesting to see how that has sort of shifted over time.
Mm-hmm. And I imagine a lot more scrutiny on the court.
Mm-hmm.
Yeah. Well, let's get into the cases. And we've already started here, so let's dive in further. The big case we're waiting on, arguably the biggest, is this Wisconsin abortion ban. Can you remind us, what are the arguments in that case? Give us some background.
Yeah, absolutely. So, without going into too much detail on all of the context, but obviously...
Right, we'd be here for hours.
We would be here for a really long time. When the U.S. Supreme Court issued their Dobbs decision, that erased 50 years of precedent, federal protections for abortion access. And when that happened, a law from 1849 here in Wisconsin kicked into place. That outlaws abortions in almost all cases, except for what many are saying is very vague language about the health of the mother, and that abortions are only allowed in, emergency situations where the life of the mother is at risk. A lot of different health institutes and OBs have said that that language is super vague, and so they don't really know when they're allowed to step in. Just a few days after the U.S. Supreme Court issued that decision, Attorney General Josh Kaul and Governor Tony Evers filed a lawsuit challenging that 1849 law. Since then, it's been a years-long legal battle, starting at the Dane County Circuit Court level with Judge Diane Schlipper, ruling that 1849 law bans feticide and not abortion. Feticide, of course, would be the intentional killing of a fetus. So she drew that differentiation, and that was appealed. And so now it's worked its way all the way up to the state Supreme Court. And it's been a long legal battle. So that
contracted, to say the least.
Yes. Yeah. And of course, after her decision, Planned Parenthood of Wisconsin resumed abortion services up to 20 weeks of pregnancy. But, that is dependent ultimately on what the state Supreme Court decides. So there's a lot riding on this, and a lot of people are waiting.
Like you said at the beginning, waiting with bated breath.
Mm-hmm.
Millions and millions of dollars went into, that was the top issue in the elections, as well. So we touched on this a little bit, but does a liberal-leaning court mean a liberal ruling? Do we have any idea about how the court may decide this?
A lot of people make that argument that a liberal majority will mean liberal rulings. I don't. I think that I've covered politics and I've covered courts for long enough to know that you never really know what's going to happen. And it might be easy to assume that, certain judges with certain ideologies will rule a certain way, but it really depends on the arguments presented to them. And when I was watching the oral arguments in November, you can really see the scrutiny that justices are approaching these arguments with, as they should, right? That's their job. So I'm interested to see what happens. I think that a lot of people are maybe sort of relaxing and assuming that a liberal majority will mean a liberal ruling, but I don't like to count my eggs before they hatch or make any assumptions, because you never really know.
You don't need to use an oversized AI model for everything, just like you don't need to use an axe to slice a cake. Find out how smaller models can deliver the right results and help cut AI costs up to 90% at IBM.com. The AI built for business. IBM. Looking for an AI glow-up that passes the office vibe check? What? AI that only knows the internet doesn't make sense for business. Get AI trained on your data at IBM.com. The AI built for business. IBM.
Are you still quoting 30-year-old movies? Have you said cool beans in the past 90 days? Do you think Discover isn't widely accepted? If this sounds like you're stuck in the past. Discover is accepted at 99% of places that take credit cards nationwide. And every time you make a purchase with your card, you automatically earn cash back. Welcome to the now. It pays to Discover. Learn more at discover.com/credit card. Based on the February 2024 Nielsen report.
Another big case right now is regarding the governor's partial veto power. So this is actually the second case challenging Governor Evers' use of that power. So can we talk about what exactly is being challenged here? Why is this important?
Yeah. So, we had the first major ruling, as you referenced, in what a lot of people refer to as the 400-year veto, where, Evers made a switcheroo with a couple of digits and extended education funding for 4 centuries, which is ridiculous sounding, but that's the current state of politics that we live in. So this second case also has to do
and just as
with
so enshrining into law the mandatory K through 12 funding increases for the next 400 years.
Correct. And the Supreme Court ruled with Evers on that one, which got a lot of backlash from Republicans in the legislature. So the second one also has to do with the governor's partial veto authority, which notably is the most flexible veto authority that any state in the country has with regard to the ability to strike out certain sections of lines. Other governors have to strike full lines or full sections of a budget. And Wisconsin gives the governor a lot of authority to be super picky about what he vetoes.
So he could strike out one word. It's like,
no? That's
it's like, this sounds like creative. Okay, creative writing.
That is what the Supreme Court is deliberating about right now. So the second case relates to $50 million allocated to a childhood literacy program. And what it brings into question is the power of the Joint Finance Committee in the legislature to decide how already allocated money can be spent. So the governor made his veto, and the Republicans in the legislature are arguing that what he vetoed isn't subject to his veto authority because it's not a budgetary bill. So the governor has the ability to do a line item veto in any allocation bill, but if a bill doesn't have a price tag on it, then it's not subject to the same partial veto authority. And because the money was already allocated and the Joint Finance Committee was looking to influence how that money would be spent, in Evers' mind, because it had to do with how the money was going to be spent, it was subject to his partial veto. In the legislature's perspective, that bill that he applied his partial veto to didn't have the money in it, so it wasn't subject to his veto power. So it'll be really interesting to see how that one pans out. And then, after that, we have a couple separation of powers, sort of agency authority cases that are going to be really interesting too.
Yeah, it sounds like the devil is in the details with that partial veto, and you laid it out really well. So thank you.
Yeah, especially in the 400-year case, when I was listening to the oral arguments before the court earlier this spring, the argument against Evers' veto authority was saying, well, we already have court precedent saying you can't strike letters, right? What a lot of people refer to as the Vanna White veto, where you can't strike letters, specific letters to make new words. However, he struck digits and not letters. So he was able to get through that loophole. So it really is in the details.
Wow.
And of course depends on individual Supreme Court justices deciding, how specific they want to get.
Well, let's talk about those agency autonomy cases, because you were alluding to that. There are a handful of cases pending that are about the autonomy of our state agencies, two of which pertain to the Department of Natural Resources, always a hot department, or the DNR. One case is about Wisconsin's spills laws. So what's going on there?
Yeah, so that is debating DNR's authority to enforce the cleanup of PFAS, that family of pesky forever chemicals that seeps into, groundwater, drinking water, and lasts forever.
And we don't know how it impacts our health.
Exactly, yeah. So it's become this really hot issue, and the argument against DNR's authority is essentially saying that they have to issue rules classifying PFAS as hazardous chemicals before they can enforce the cleanup. So just sort of delaying their ability to enforce the cleanup of this. Of course, DNR is saying, obviously it's been classified as hazardous at the federal level, so we should be able to enforce the cleanup. So that's sort of blocking DNR's authority. And then, the other one you mentioned also has to do with DNR, which beyond just their authority, even the appointment process with DNR has been long and convoluted. So there's a lot of drama having to do with that particular agency, the legislature blocking Evers' appointments for the past couple sessions. So it's always interesting seeing what goes on with that particular department. But yeah, the other one has to do with whether the legislature can reject certain rules that agencies like the DNR have already proposed.
It sounds like a possible overreach, I assume, is the argument of the department, which is like, hey, you guys do the budget and make laws, and then we're a department and we make our rules. in our purview. Stay on your side.
Yeah, I mean, that is the argument, is that there needs to be a separation of powers and that the legislature shouldn't be deciding how an agency does their business once they get their budget. You know, they give them their budget allocation, and then the agency is supposed to do their job, which in DNR's case has to do with, you know, natural resources, water, land, et cetera. And so that's DNR's argument, is essentially, like you said, get out of our lane. And the legislature is arguing that they have the power to reject certain rules that the DNR has proposed. So there's some interesting ones that will sort of set the stage. Like I mentioned, you know, earlier, a lot is sort of being carried by these lawsuits that will decide what future lawsuits maybe are also brought forward, depending on the result of these rulings.
Well, you know, I want to talk about the future of the court. You mentioned that when justices come back in the fall, then now Justice-elect Susan Crawford will join the court, replacing Ann Walsh Bradley, who served on the bench for 30 years, so 3 terms. I'm curious, do you expect Crawford's entrance will make any big, distinct changes for the court?
I mean, I think that in 2023, obviously, when the ideological makeup of the court flipped with the election of Justice Protasiewicz, that was a big, big deal because the makeup was changing. Like you mentioned, in this case, Justice-elect Susan Crawford is replacing another liberal-leaning justice, Ann Walsh Bradley, who's retiring. So the actual, you know, ideological leanings of the court won't change all that much. When I spoke with Crawford throughout her campaign, she played it pretty close to the vest with regard to her own sort of political convictions. I think a lot of voters wanted her to be a little more forthright about where she stood on certain issues. But when I pressed her on that, she would always kind of say, well, that's not my job.
Right.
My job is to judge the cases in front of me. So,
right. And when we interviewed her, too, that was the same outcome. And I remember her kind of looking at me like, I remember saying something like, your record shows that you're liberal leaning. And she was like, well, excuse me? Like, she kind of just like, pushing back at the idea that she is political or that she will be political and that she'll be making every single decision, you know, like you said earlier, the evidence that's presented, like you have to hear each case individually.
I will say between this last Supreme Court campaign and the one in 2023, the candidates approached very differently their publicity surrounding their views on things.
Totally.
Justice Protasiewicz was very outspoken about abortion access, for example, about legislative maps. And so a lot of folks sort of knew what to expect from her. And yeah, like you ran into and like I ran into when you asked Susan Crawford how she felt about certain cases, like the abortion case, she would be like, well, hey, I didn't hear the argument, so it's not my job to rule on something that, you know, the court's currently deliberating on, which I think some people were happy about, and it irked other people who, you know, wanted to know her stance on things a little bit more. So yeah, as far as the makeup of the court, that's not changing, but every justice has their own style. So I think it will be really interesting to sort of see her take that role on the state Supreme Court and how she approaches it.
Well, last month, Wisconsin appeals court judge Chris Taylor officially announced her candidacy for the Wisconsin Supreme Court. She's vying for the seat currently held by conservative Justice Rebecca Bradley. It's a different Bradley. Just to note, there are 2 Bradleys in this conversation. Justice Rebecca Bradley will be up for re-election next April. So, Erin, we are already in election season again, huh?
Oh my God, we never get a break. We never get a break. November happened, and then immediately we started preparing for April. And now immediately we're talking about the next Supreme Court race and the governor's race and the midterms. So that's just life in Wisconsin.
So true. You keep those election signs up all year. Well, Erin, thank you so much for joining us and bringing us up to speed. We love being informed on the state government, and you've got the beat. Thank you so much.
Thank you so much.
That's Erin McGroarty, state government and disinformation reporter at the Cap Times. If you want to check out her reporting on the court and more, head to our show notes for a link. And hey, while we're talking about outstanding decisions and making judgments, Madison Magazine's Best of Madison Awards final voting round is live, and CityCast Madison is up for Best Local Podcast and Best Local News Website. Would you help us claim the title? Dub us Best of Madison? If you value our work, if we bring value into your life, we'd absolutely love your support. The link to vote is in our show notes. That's all for today, here on CityCast Madison. I'm Bianca Martin, your host. If you enjoyed the show, why not share this episode with your most judicious friend? All right, we'll be back tomorrow morning with more stories from around the city. Until then, take good care.